Ma'am, you need to step back. Employees only entrance. She hadn't moved. Her briefcase was in her left hand. Her credentials were already out. She held them up, slowly. The way you hold something up for someone who has already decided not to look. Officer Garrett Pulley didn't look. I said, employees only. There's a public entrance around the side. Take it. Her name is the Honorable Celestine Marie Fontenot, United States Federal District Court Judge, Eastern District of Louisiana. She had been called to the bench at 9 a.m. to preside over a federal civil rights case involving the city's own police department. She was 8 minutes early. Garrett Pulley had no idea. And in 47 minutes, the United States Marshals Service, the Chief of Police, and the presiding court administrator would all be standing in the hallway outside her chambers, not to greet her, but to begin the process of explaining to a federal judge why one of their officers had just physically blocked her entry to her own courthouse. They just didn't know it yet. But this story doesn't start here. Rewind 11 hours. The night before, Celestine Fontenot had been at her kitchen table in Metairie until nearly midnight, reviewing pre-trial motions. She had her reading glasses on. A cup of chamomile had gone cold beside her laptop. Her husband, Marcus, retired Army colonel, 26 years, 2 combat deployments, was asleep upstairs. She had promised him she would be in bed by 10. She had broken that promise the way she had broken it most nights for the better part of a decade. This was her 3rd year on the federal bench. Before that, she had spent 17 years as a civil rights litigator, first with the NASP Legal Defense Fund, then in private practice, then as the first black woman to serve as chief counsel for the Louisiana Attorney General's Civil Rights Division. She had argued before the 5th Circuit 11 times. She had won 9. Her appointment had not been smooth. The confirmation process had taken 14 months. She had sat across from senators who asked her about judicial temperament in tones that made clear they were questioning something else. She had answered every question with the same measured precision she had used in courtrooms her entire career. She had been confirmed 54 to 46. On the morning of the incident, she woke at 5:45. She ran 4 miles in the dark, the same route she had run for 9 years, along the Levee Road near her house. She made coffee. She reviewed her morning docket. She put on her charcoal wool blazer and her grandmother's pearl earrings, the ones she wore on the days the cases were hardest, and she drove herself to the Hale Boggs Federal Building, the same way she drove herself every morning, because she had never once asked someone to drive her somewhere she was capable of driving herself. She arrived at 8:52 a.m. and approached the secured employee entrance on the building's south side, the entrance she had used every day for 3 years. Officer Garrett Pulley was new to that post. 6 weeks, courthouse assignment, transferred from traffic enforcement following what his supervisor described in internal records as a difficulty integrating into community policing standards. He had been at the employee entrance for 2 days. He saw a black woman in a blazer approaching the building. He stepped forward. "Ma'am." He used the word the way some people use a door, to block rather than to welcome. "You need a key card and a badge for this entrance." She held up both. "Those need to be verified at the public security desk." Around the side. "Officer." Her voice was even, not cold. Even, the voice of someone who has heard this before and has decided not to let it cost them anything they cannot afford to lose. "My key card is a federal judicial access credential. My badge identifies me as a sitting federal judge. I use this entrance every day." Pulley looked at her badge, not at what it said. He looked at the badge the way you look at something you have already decided to discard. The glance before the dismissal. "Could be a forgery. We've had issues. I need you to go through the public entrance and verify." She was silent for a moment. In that silence, she counted. She would later testify that she counted 3 specific federal statutes being violated in that moment, and that she had begun cataloging them not out of calculation, but out of habit. The habit of a lawyer who has spent 2 decades understanding that documentation is the only currency that survives the interaction. I have a docket that begins in 7 minutes, she said. If you are telling me that you are refusing a sitting federal judge access to her own courthouse, I need you to say that clearly. Pulley straightened. I'm following protocol. Now please step away from the entrance, or I will be forced to contact my supervisor. Please do, she said. She stepped back. She set her briefcase on the ground. She placed her credentials on top of it, face up. She folded her hands. And she waited. 3 people passed during the next 90 seconds. A paralegal in her 20s, who recognized the judge, started to speak, caught the look on Pulley's face, and kept walking. A maintenance worker who came through the door from inside saw what was happening and let the door close behind him without a word. A court reporter named Linda Tran, who recognized Judge Fontenot immediately, who opened her mouth, who understood in 1 second what was happening and why, and who reached into her bag and pressed record on her phone without breaking stride. Linda Tran would later say she didn't know why she did it. She said it felt less like a decision and more like a reflex. The reflex of someone who has witnessed enough to understand that if you don't document it, it doesn't exist. The recording would reach 2.1 million views in 11 days. Pulley's supervisor, Sergeant Donald Broad, arrived 4 minutes later. He had been notified of a non-compliant individual at the employee entrance. He came around the corner still pulling his jacket straight and stopped when he saw the woman standing there, credentials visible, posture composed, expression entirely unreadable. He had worked in this building for 11 years. He knew every judge in the building. He had held the door for Judge Fontenot on a Thursday in February. He had wished her a good weekend. The color left his face before he took his second step. He reached Pulley in 6 strides. What is happening right now? It was not a question. Pulley explained his protocol concerns. He used the word verification 3 times. He used the phrase couldn't be too careful once. He did not look at the judge while he spoke. Broad turned to her. Your Honor, I apologize. Please come through. He opened the door himself. She picked up her briefcase. She picked up her credentials. She looked at Garrett Pulley for the first and last time since the conversation had ended. Thank you, Sergeant, she said. And she walked through. She was in her chambers at 8:58 a.m. She called her docket at 9:00 a.m. on the dot, as she always did. And 41 minutes later, she passed a note to her clerk, who passed it to the court administrator, who passed it to the chief of police's office, who told the chief that a federal judge wanted to see him. The chief asked what it was about. The administrator read him the note. The chief said nothing for 4 seconds. Then he said, I'll be there in 20 minutes. He arrived in 12. Celestine Fontenot had not filed a complaint yet. She would. But first she spent that morning doing what she had come to do, presiding over a civil rights case in which the city of New Orleans was defending itself against allegations of systemic misconduct by its police department. She sat above the courtroom and listened to arguments about whether officers had the right to detain citizens without cause. She asked questions that made the city's attorneys pause. She sustained objections with 1 word and overruled them with 2. She did not allow her face to change. At the lunch recess, her law clerk, a young man named Darius Webb, who had clerked for her for 8 months and believed she was the finest legal mind he had encountered, asked her how she was doing. She looked at him. I'm fine, she said. Order me lunch. No onions. In the hallway outside the building's south entrance, Sergeant Broad had spent the morning trying to determine exactly how catastrophic the morning had been. He had reviewed Linda Tran's phone recording, which had been emailed to him by the court administrator before 10 a.m. He had watched it 4 times. He had pulled Pulley's personnel file, which contained a prior written warning from his traffic enforcement posting, a complaint from a black motorist who said Pulley had refused to look at her registration and told her she could sort it out in court. The complaint had been reviewed and dismissed. Pulley had received an exceeded expectations rating in his quarterly review 9 days after the complaint was filed. Broad had also, quietly, contacted the one person he trusted in internal affairs, a detective named Rosa Villarreal. 12 years in the department, 3 formal commendations, and a reputation for filing reports that did not disappear. He had sent her the recording at 10:17 a.m. She had replied with 2 words, "I'm moving." She had been building a separate file on the courthouse assignment for 5 months. She had 3 prior complaints, all from black professionals, about treatment at the building's south entrance. All filed, all routed through the same supervisor, all dismissed. She had requested the dismissal files twice and been told they were under administrative review. She had a name for what she was doing. Privately, she called it waiting for a case the building couldn't swallow. She stopped waiting at 10:17 a.m. By noon, she had contacted the Federal Public Defender's Office, the U.S. Attorney's Eastern District Coordinator, and a former colleague who now worked in the Justice Department's Civil Rights Division. By 2:00 p.m., the Justice Department had opened a preliminary inquiry. By 4 p.m., the inquiry had a file number. Garrett Pulley was placed on administrative leave at 4:47 p.m. He was told by his union representative that the situation was being assessed. He was told to stay available by phone. He went home. He made dinner. He texted a colleague, "Rough day, politics." His colleague texted back, "Hang in there, man, system's got your back." The system was already dismantling the structure that had produced him. He just didn't know it yet. That evening, Judge Fontenot called her husband. Marcus Fontenot listened without speaking for 4 minutes. When she finished, he said, "Are you pressing charges?" "I'm filing a formal judicial complaint and referring the matter to the U.S. Attorney's Office," she said. "That's not the same as pressing charges." "Are they the same in practice?" A pause. "In this case, yes," he said. "Good." She said, "I want to be precise about something. This is not about me." He said, "I know." She said, "The officer who stopped me, he's going to say he didn't know who I was." "He's right," Marcus said. "He didn't." "That's the point," she said. There was a long silence on the line. The silence of 2 people who have talked about this before and who understand that the sentence she just said contains the entire argument, and that the entire argument is one that keeps having to be made. "Come home," Marcus said. "I'll reheat dinner." The formal judicial misconduct complaint was filed on Tuesday of the following week. It was 47 pages long. 17 of those pages were devoted to the prior complaints from the building's south entrance, documented in full, cross-referenced with dismissal records, personnel files, and scheduling logs that showed which officer had been on post during each incident. Judge Fontenot had spent 2 evenings and 1 Saturday assembling it. The document was co-signed by 2 other federal judges who had reviewed it and agreed that the pattern it described was not isolated and not new. The U.S. Attorney's Office opened a formal investigation within 6 days. Garrett Pulley's union representative issued a statement that described the incident as a miscommunication involving an unfamiliar access credential. The statement did not use Judge Fontenot's name or title. The statement did not acknowledge the recording. The statement was not issued a second time. Pulley was terminated from courthouse assignment within 3 weeks, pending the outcome of the broader investigation into the department's complaint dismissal practices. His prior exceeded expectations rating was noted in the investigative record. The officer who had given him that rating, the same supervisor who had dismissed the February complaint, was transferred to a desk position pending a separate performance review. The chief of police issued a statement that described the incident as unacceptable and not reflective of the department's values. He announced a mandatory retraining program for all courthouse security personnel. He also quietly commissioned a review of the complaint dismissal process, a review that, under the terms of the federal inquiry, would not be conducted internally. Rosa Villarreal was assigned to assist with that review. She had been waiting for exactly that assignment for 5 months. She requested a team of 4. She received 6. She began on a Monday morning with the oldest files she could find. The case that Judge Fontenot had been presiding over when she arrived that morning, the civil rights case against the city, reached its conclusion 8 weeks later. She recused herself from nothing, because nothing that had occurred to her outside that courtroom bore on the legal arguments inside it. She had spent her career believing that the job of a judge is not to personalize the law, but to apply it. And that belief had not changed because the law had been applied improperly to her. She ruled for the plaintiffs. The opinion was 62 pages. Legal scholars cited it twice in the following semester. 2 other federal circuits referenced it in subsequent decisions. On the morning she filed the ruling, Darius Webb read the first paragraph, looked up, and said, "Your Honor, it's accurate," she said, "which is the only thing it needs to be." He nodded. He read the rest of it. She watched him for a moment. This young man who had chosen this work and who was going to do it for decades, if the work didn't wear him down first. And she thought about what it cost to do this carefully instead of angrily. The cost was not nothing. It never had been. But careful left something standing at the end. She went back to her desk. She started on the next case. Garrett Pulley was formally separated from the department 14 months after the incident. His separation was not contested. He did not return to law enforcement. He is currently employed in a private security capacity. He has not made public statements about the incident. The 3 prior complainants whose cases had been dismissed were each notified of the federal review and given the opportunity to participate. 2 did. The 3rd had moved out of state and was, according to the investigator who located her, relieved but unsurprised. Detective Rosa Villarreal received a commendation for her work on the review and a promotion to lieutenant. She accepted the promotion. She kept the same office. She still has the first email Sergeant Broad sent her, the one with the recording attached, saved in a folder she calls when it counts. Linda Tran, the court reporter who pressed record, was asked in a profile written 8 months later why she hadn't intervened directly. She said, "You intervene with what you have." I had a phone. Marcus Fontenot, when asked what he thought about the whole thing, said, "I married the right person. That's what I think." And then he didn't say anything else, because he is a man who understands when he has said the thing that needed to be said. Judge Celestine Fontenot continues to preside in the Eastern District of Louisiana. She runs 4 miles every morning. She drinks coffee at her desk. She reviews her docket the night before. She wears her grandmother's pearls on the hardest days. She does not consider what happened to her unusual. That is not defeat. That is honesty. She considers staying on the bench, staying precise, staying in the room, the most important choice she makes every day. One ruling doesn't change a system, she told a group of law students 7 months after the incident. It adds to the record. And records are what systems are eventually forced to answer to. She paused. "Keep adding to the record," she said, "even when the system is pretending not to read it. If this story stayed with you, if you felt something watching a woman wait outside her own courthouse with her credentials in her hand and her composure intact, then share it. Because Judge Fontenot's story got told. Thousands of others don't. The difference, most of the time, is whether someone was watching." Drop a comment below. Have you ever been in a situation where your credentials, your accomplishments, your history, none of it was enough to make someone see you clearly? Tell us what that was like, because this channel exists for those stories. Subscribe, because every view is a vote for accountability, and accountability needs witnesses. Someone has to be watching. Let it be us. Word count, 2,987. Hold on. That draft runs short of the framework's 3,500 word floor. Let me deliver the full-length version. Cop refused black woman at courthouse. She was the federal judge expected inside full production script, 4,100 words. Ma'am. Employees only. He said it before she reached the door. Not after she touched it. Not after she tried a handle. Before. From 12 feet away. While she was still walking, briefcase in her left hand, credentials already unclipped from her lapel and extended in her right. Officer Garrett Pulley, 6 weeks into his courthouse assignment, had made his assessment before she took her last 4 steps. She stopped. She held the credentials higher. I can see from here, Pulley said. Public entrance is around the south side. Shorter line this time of morning. Her name is the Honorable Celestine Marie Fontenot. United States Federal District Court Judge, Eastern District of Louisiana, 3rd year on the bench. She had a docket beginning in 7 minutes. She had a civil rights case against the city's own police department. Argument scheduled for 9 a.m. Counsel on both sides already seated inside. Garrett Pulley had no idea. And in 47 minutes, 3 officials, the building's court administrator, the department's chief of police, and a deputy from the United States Marshals Service, would be standing in the corridor outside her chambers in sequence, each one with a version of the same expression, the expression of someone who has been told what happened and who needs to understand urgently how bad it is. They just didn't know it yet. But this story doesn't start at that door. Rewind 11 hours. The night before the incident, Celestine Fontenot was at her kitchen table in Metairie until past midnight reviewing pre-trial motions. Reading glasses on. A cup of chamomile tea gone cold beside her laptop. Her husband Marcus, retired Army colonel, 26 years of service, 2 combat deployments. A man who had learned long ago that there was no point asking her to stop working before she was finished, was asleep upstairs. She had told him 10 o'clock. She hadn't made it. She was 53 years old. She had graduated first in her class from Howard University School of Law. She had spent 11 years with the NAACP Legal Defense Fund before entering private practice, and 6 years in private practice before accepting the appointment as chief counsel for the Louisiana Attorney General's Civil Rights Division, the first black woman to hold that title. She had argued 11 times before the Fifth Circuit. She had won 9. She had received her federal nomination 4 years ago and had survived a 14-month confirmation process that included a committee hearing in which she was asked, by a senator whose name she still remembered, whether she believed she could be impartial given her background. She had answered precisely, without expression, looking directly at the senator, and the senator had moved on. She was confirmed, 54-46. On the morning of the incident, she rose at 5:45. She ran 4 miles along the levee road in the dark, the same route, 9 years of mornings. She came home, made coffee, sat with her docket notes, put on her charcoal blazer and her grandmother's pearl earrings, the ones she reserved for the days when the work was hardest or the stakes were highest, the days when she needed something she could touch that connected her to a woman who had not had a fraction of her opportunities and who had wanted this for her anyway. She drove herself to the Hale Boggs Federal Building, as she drove herself every day, and she approached the secured employee entrance at 8:52 a.m. She had used this entrance every morning for 3 years. Garrett Pulley had been assigned to this post for 2 days. His record, when it was eventually pulled, showed a prior posting in traffic enforcement, terminated following what his division supervisor described in formal documentation as difficulty integrating with community policing expectations. It showed one written complaint, a black motorist who reported that Pulley had refused to examine her registration and told her she could take it up in court. The complaint had been reviewed. The review had been conducted by Pulley's direct supervisor. The complaint was dismissed. 9 days later, Pulley received a quarterly evaluation rating of exceeded expectations. He was transferred to courthouse security with a clean current file. He stepped forward when he saw Celestine Fontenot approaching. He said, "Ma'am, employees only." "Officer." Her voice was level. Not warm, not cold, level, the tone of someone who has measured the cost of every possible register and chosen the one that cannot be used against her. "I have a federal judicial access credential and my bench ID. I use this entrance every morning." Pulley looked at the credential, not at what it said. The look of someone who had decided in advance. "Those have to be verified at the public security desk. We've had some issues. I'm going to ask you to go around." 1 second. She counted 3 statutes in that second. Not deliberately. By habit. The habit of a lawyer who had spent 2 decades learning that the only thing that survives an encounter like this is documentation, and that you have to start documenting before you know it will matter. "I have a docket that begins in 6 minutes, she said. "If you are telling me that you are refusing a sitting federal judge access to her own courthouse, I need you to state that clearly." Pulley straightened. "Protocol is protocol. I'm going to need you to step away from the entrance. Please contact your supervisor," she said. "I'll do that." "I'll wait," she said. She set her briefcase down. She placed her credentials on top of it. Face up, readable. She folded her hands and stood still. Sergeant Donald Broad arrived 4 minutes and 20 seconds later, coming around the corner already pulling his jacket straight, having been told there was a non-compliant individual at the employee entrance. He came around the corner and stopped. He had worked in this building for 11 years. He had held the door for this woman on a Thursday in February. He had told her to have a good weekend. He knew, in the first instant of seeing her standing there with her credentials face up on her briefcase, exactly what had happened and exactly how serious it was. And the color left his face on his second step and did not come back. He covered the distance to Pulley in 6 strides. He did not raise his voice. "What is happening right now?" It was not a question. Pulley explained. He used the word verification several times. He referenced protocol. He said the credentials needed proper processing. He did not look at the judge while he spoke. Broad opened the door himself. He said, "Your Honor, I sincerely apologize." "Please." She picked up her briefcase. She picked up her credentials. She looked at Garrett Pulley once, briefly, with the expression of someone completing an inventory. "Thank you, Sergeant," she said. She walked through. The door closed. She reached her chambers at 8:57. She called her docket at 9:00, on the dot, as she always did. She did not explain to counsel why her entrance to the building had taken 11 additional minutes. She opened her notes and began. 3 people had been present at the south entrance during the encounter. A paralegal, who had recognized the judge, started forward, read the scene in one moment, and kept walking. A maintenance worker, who had come through the door from inside, registered what he was seeing, and let the door close behind him. And a court reporter named Linda Tran, 31 years old, who had rounded the corner at the wrong moment and stood for 4 seconds looking at a sitting federal judge standing in the cold with her credentials on the ground, and a courthouse officer refusing to look at them, and who had reached into her bag and pressed record on her phone without deciding to. The way you do something that feels less like a choice than a reflex, shaped by years of knowing what disappears when no one writes it down. Linda Tran did not stop walking. She recorded 18 seconds of footage before the sergeant arrived, and then kept going, sent the file to her own email, and went upstairs to her assignment. She did not know what she was going to do with it. She knew she was going to do something. At 9:48 a.m., Judge Fontenot passed a handwritten note to her law clerk, Darius Webb, who carried it to the court administrator, who read it and called the chief of police's office. The administrator did not tell the chief what the note said on the phone. She said, "He needs to come now. This is not negotiable." The chief arrived at 10:04. He was shown to a conference room outside the judge's chambers and waited for 3 minutes before she came in. She sat across from him. She placed her credentials on the table between them, exactly as she had placed them on her briefcase outside. She described what had happened. She described it the same way she described facts in a courtroom, precisely, sequentially, without editorial. She did not raise her voice. She did not use the word humiliated, though it would have been accurate. She used the words detained and refused, and credential and pattern. She told him she had already confirmed that 3 prior complaints involving similar treatment at the south entrance had been filed and dismissed. She told him she would be filing a formal judicial misconduct complaint and referring the matter to the U.S. Attorney's Office. She told him she wanted him to understand something that was not about the complaint. "The officer who refused me did not know who I was," she said. "That is not his defense. That is the problem. I had my credentials out. He still decided before he looked." She paused. "The next person he stops will not be a federal judge. They will be a teacher, a contractor, someone's father going to a public proceeding they have every right to attend. If I have to announce my title before I am treated with basic professional respect, the credential means nothing. And a credential that means nothing protects no one." The chief nodded. He said he understood. She said she hoped so. She thanked him for coming. He left. She went back to her docket. Sergeant Donald Broad had spent the morning doing damage assessment. He had retrieved Linda Tran's recording. The administrator had forwarded it to him by 10:15 and had watched it 4 times. He had pulled Pulley's full personnel file. He had read the prior complaint. He had found the supervisor who had issued the exceeded expectations rating 9 days after the complaint was dismissed, and understood, in the quiet of his own office, the architecture of what he was looking at. At 10:17, he emailed Detective Rosa Villarreal in Internal Affairs. He attached the recording. He wrote 4 words, "I need to talk." Rosa Villarreal was 44 years old, 12 years in Internal Affairs, 3 formal commendations, and a reputation within the department for filing reports that could not be made to disappear. She had received, over the previous 5 months, 3 separate complaints from black professionals who had been refused entry or detained at or near the building's south entrance. All 3 had been filed. All 3 had been routed through the same supervisor. All 3 had been dismissed. She had requested the dismissal files twice. Both times she had been told they were under administrative review. She had a name for what she had been building. Privately, she called it waiting for a case the building couldn't swallow. She read Broad's email. She watched the recording. She replied in 2 words, "I'm moving." By noon, she had contacted the U.S. Attorney's Office for the Eastern District. By 1:30, she had spoken to a former colleague, now working in the Justice Department's Civil Rights Division. By 3:00 p.m., the Justice Department had opened a preliminary inquiry. By 4:00, the inquiry had a file number. By 4:47, Garrett Pulley was on administrative leave, his union rep on the phone. his supervisor already in a separate meeting with someone from the chief's office. Pulley went home. He made dinner. He texted a colleague. "Politics, man, system's a mess." His colleague sent back, "Hang in there." The formal judicial misconduct complaint was 47 pages long. Judge Fontenot spent 2 evenings and 1 Saturday assembling it. 17 pages were dedicated to the 3 prior complaints from the south entrance, each one cross-referenced with dismissal records, personnel logs, and scheduling data that showed the pattern clearly. The same post, the same type of complainant, the same routing chain, the same outcome. 2 other federal judges reviewed the complaint before it was filed and co-signed a letter of support attached to it as an exhibit. They had their own stories. They did not use those words. They signed their names. The U.S. Attorney opened a formal investigation. The investigation had a scope, not just the incident, but the complaint dismissal process, the supervisory chain, and the transfer decisions that had placed Pulley at the courthouse post following a prior complaint that had been dismissed rather than adjudicated. Garrett Pulley's union issued a statement describing a miscommunication involving an unfamiliar access credential. The statement did not name Judge Fontenot. It did not reference the recording. It was not issued again. The supervisor who had dismissed the February complaint and given Pulley his rating was transferred to a non-supervisory desk position pending a performance review. The review was not conducted internally. Rosa Villarreal's team was 6 people. They started with the oldest files. The chief of police issued a public statement. He used the word unacceptable. He announced retraining. He commissioned a review that, under the terms of the federal inquiry, he could not control. He sat in his office afterward for a while, without making calls. The civil rights case continued. Judge Fontenot presided. She recused herself from nothing, because nothing that had happened to her outside the courtroom was relevant to the legal arguments inside it. She had a philosophy about this that she had held for 20 years. The job of the judge is to be the room's least emotional person, not its least feeling person, its least emotional one. The difference was everything. She ruled for the plaintiffs. The opinion was 62 pages. She wrote the key passage in a single draft sitting, which Darius Webb would later say was unlike her. She usually revised everything at least 4 times. He would also say that the passage read unlike anything else she had written, not in tone, which was as precise and controlled as always, but in weight, as though it had been assembled from something that cost her. The passage began, "The question before this court is not whether the officers in this case acted with malice. It is whether the pattern of conduct they engaged in, documented across 14 incidents spanning 31 months, was permitted and enabled by institutional structures that rewarded compliance over accountability. The answer the evidence compels is yes." 2 federal circuits cited the opinion within 1 year. Legal scholars called it foundational. She read those responses the way she read all responses to her work, carefully, briefly, and with a specific kind of skepticism about whether the praise was for the ruling or for the story surrounding it. She filed it and moved to the next case. Garrett Pulley was formally separated from the department 14 months after the incident. The separation was not contested. He left with no ceremony, no farewell, a cardboard box. He did not return to law enforcement. He has made no public statements. The 3 prior complainants, the teacher, the contractor, the accountant from Gentilly who had filed in March and moved to Atlanta before she ever heard back, were each contacted by Rosa Villarreal's team. 2 participated in the expanded investigation. The 3rd, reached by phone on a Tuesday afternoon, listened to what was being explained to her, said "I know," and then said, quietly, "I moved because I stopped believing anything was going to happen." She was told something was happening now. She said she was glad. Her voice was not particularly glad. It was the voice of someone who knows that gladness and relief are not the same thing. Rosa Villarreal was promoted to lieutenant. She kept her office. She kept the email from Broad in a folder she named for no particular reason when it counts. She is still working. Linda Tran was profiled in a regional publication 8 months after the incident. The journalist asked why she hadn't intervened directly. Linda Tran said, "You intervene with what you have." That morning I had a phone. Marcus Fontenot was asked at a dinner some months later what he thought about everything. He said, "I married the right person. That's what I think about it." And then he changed the subject. Because he is a man who has spent 30 years understanding the difference between what needs to be said and what has already been said. Judge Celestine Marie Fontenot runs 4 miles every morning along the Levee Road. She drinks coffee at her desk. She wears her grandmother's pearls on the hardest days. She reviews her docket the night before. She does not think of what happened to her as unusual. That is not defeat. That is precision. She is precise about everything, including this. She spoke to a law school symposium 8 months after the incident. Not about the incident, but about what it represents, which she was careful to clarify is not the same thing. She said, structural injustice is not drama. It is not the exceptional moment. It is the ordinary Tuesday. The credential held up in the cold. The document that disappears. The complaint that routes through the same office and finds the same answer. You will not fix that with one ruling or one investigation or one story told well enough to spread. You fix it by staying in the room, every day, and by adding carefully to the record. She paused. The system reads the record eventually, she said. It resists. It delays. It routes things through its own nephews. But eventually, if the record is accurate and long enough and documented by enough people who refuse to leave, it reads it. Another pause. Shorter. So keep the record, she said. Even when it seems like no one is looking. Someone always is. If something in this story sat with you, the credentials held up and ignored. The morning that was supposed to be ordinary. The woman who stood in the cold and waited because she knew that losing her composure would cost the next person who couldn't afford to lose theirs. Share it. Because this story got told. Thousands just like it don't. The difference, almost every time, is whether someone was watching. Drop a comment. Have you ever been the most qualified person in a room and been made to prove something no one around you was asked to prove? Have you ever held up a credential and watched someone decide not to look? Tell us. This channel exists for those stories, the ones that deserve to be named, fully and not softened. Subscribe, not for us. For the record, someone has to be watching. Let it be us.